Good morning, Chief Justice.
How are you?
I am well, and how are you?
I'm fine, thanks. Just close the door. You hold a BProc degree from the University of the North.
Yes, Chief Justice.
And you're an attorney through and through. That's all you've ever done.
That's all I know.
You did your articles and then started practicing in 1996.
Yes.
And then you did a few things. You were in a partnership, then you ran your own solo practice. But until 2020,
Yes.
and since 2022, you're a consultant.
Correct,
at
Chief Justice.
Nguni Attorneys. Okay. You have sat in the executive committees and at some stage or the other chaired both the then Northern Provinces Law Society and NADEL.
Correct,
of
but
which
Nadel was not national. It was the Mpumalanga branch of
Oh, I
Nadel.
see. Okay. And you've also presided in the Small Claims Court.
Indeed, Chief Justice.
Okay. You have acted, you've, as a practitioner, you describe a practice, a mixed practice that includes a huge portion of labor law work.
Correct, Chief Justice.
All right. So you've appeared regularly in the labor court as well as in the High Court.
Correct.
And you have acted as a judge, of course.
Indeed, I have.
And you say you've acted since 2013 until this year for a cumulative period of about 3 years. Is
Yes,
that right?
the most recent calculation that I have, the cumulative period is actually 4 years.
4 years.
Yes.
All right. The first stint having been in 2013.
Correct, Chief Justice.
In which divisions? What division?
The division has always been Gauteng, but at the time, the Gauteng division was responsible for circuit courts in both Mpumalanga and Limpopo. So I did stints in both Limpopo and Mpumalanga, and after Mpumalanga was established, I did some stints there.
And during these acting stints, you've written over 100 judgments.
Yes,
How many is it?
My count is at 150 or thereabouts.
And you say some have been confirmed by the SCA, with some confirmed, others have said, and that 2 have been confirmed by the Constitutional Court.
Correct, Chief Justice. My calculation, and this also appears from comments from the GCB, is that 4 were confirmed by the SCA and 4 were upset.
And 1 of your judgments is reported?
2.
Oh, it's 2 now?
Yes.
Right. What are they about, briefly?
The one matter was about, it was a criminal appeal matter, and it was whether or not minimum sentence legislation is applicable to accomplices. And I found that it was, and they thought that ought to be reportable. The second one was about, was a matter where an applicant before me was going to leave the country for a sex change operation as a man, but come back as a woman. So an urgent application was brought seeking to compel Home Affairs to alter the traveling documents of the applicant so that when she comes back as a woman, she doesn't get into difficulties with immigration officials. So I penned a judgment. I made a ruling there on an urgent basis that Home Affairs ought to alter the traveling papers so that she can live as a man and come back as a woman and not get into trouble.
All right. You have not listed any reserved judgments as far as I can see.
No, Chief Justice, at the time they were not, but I have acted again since then.
Yes.
And I've picked up about 4 reserved judgments.
But they are well within the
Yes, it was in
requirements
August.
of the norms.
Yes, it was
Okay.
in August.
Well, the commentary from some of the law bodies is that you have a good turnaround on judgment delivery.
It's excellent, thanks.
Okay. There is one issue, though, that has caught the attention of almost all the law bodies who have sent in comments about your candidacy. Your suspension from practice for a period of 18 months, not so long ago, and the complaint is that you do not appear to take this as seriously as you should, and you have been you've not been generous with the information you've placed before this body. You've not explained it adequately.
Yes.
Would you mind explaining what that was about, what had happened?
Thank you, Chief Justice. I'm happy to explain. When completing the questionnaire, I did indicate that the transgressions which led to my suspension were administrative in nature. And it would appear that when the law bodies picked up on this, they got the impression that I was sort of trivializing the fact that I was suspended and that I was suspended for administrative issues, or that suspension was administrative in nature. I prepared a memo when the complaints came, and I explained myself that I had used administrative in nature is the terminology of the judgment for my suspension, that the judges felt that the transgressions or the offending conduct was administrative in nature. In no way am I trivializing or minimizing my offending conduct.
So you have not practiced for your own account since the lapse of the suspension period?
No, I have not. What I have done, though, was to apply for the upliftment of the order of suspension and to seek permission to once again be permitted to practice, and the High Court granted an order for me to resume practice.
Oh, it has been granted?
Correct, Chief Justice.
All right. Thank you, Mr. Thobane. JP, do you have questions for this candidate?
Yes, thank you, Chief Justice. I see in your CV career summary, you mentioned Lepoko Ledwaba and Sekaki. Who was your principal?
It was you, AJP. You are the one who signed my fit and proper affidavit.
Yeah, I hope I did a good job when you were still a candidate. And I just also want to disclose that you're my candidate and you are also my PA at a certain moment.
Yes, that is true.
You've also mentioned my name for references in your CV.
Yes. May I just explain that aspect, AJP? When the application was made, Deputy Chief Justice Mlambo was still the JP of Gauteng. And obviously, when I prepared the questionnaire, I had no idea that at some point you'd be the acting JP. So the explanation I can profile is that at the time when I prepared the CV and the questionnaire, the Deputy Chief Justice was still the Judge President of Gauteng.
You also state that you were a commissioner at the Small Claims Court until 2013.
Yes.
Why did you decide to not to be a commissioner any further after 2013?
2013 was the year I was approached to act as a judge, and it just became too difficult for me to act as a judge or to be an acting judge while at the same time doing duties as a commissioner of the Small Claims Court, because they generally take place after hours.
Yeah. Then, after your suspension, it was on 14 May 2021 to September 2025 when the suspension was uplifted. What were you doing?
So come again.
What were you doing between May 2021 and September 2025 when the suspension was uplifted?
When it was uplifted, I then did some consulting work.
Okay, can you maybe explain in detail what do you mean by consulting work?
Consulting work was I would be approached by legal practitioners to give assessment of witness statements in criminal matters and to also assist them with interpretation of contracts. It was generally that kind of interaction. I never consulted with any clients or appeared in court.
Did you charge a fee for the services you were rendering?
No, I did not charge a fee. It was just for my personal development to keep my mind busy during that period.
And I looked at the court order that was granted recently in September 2025. What relief did you seek when you filed your application for upliftment?
When I was approached to make myself available for the vacancies in Gauteng, one of the requirements is that one ought to file a letter of good standing. So when I approached my professional body with Thank you, Chief Justice. When I approached my professional body to be supplied with a certificate of good standing, they informed me that they could not issue out that certificate because, in their view, I was still under suspension. I was suspended by a court of law, and the only thing that should happen is that a court of law is the only body that can uplift my suspension. So the court application was informed by the response of the professional body, the Legal Practice Council, that I ought to approach the court to get an upliftment as well as to expeditiously be supplied with a letter of good standing. So then I brought an urgent application requesting the court to lift the suspension and also requesting the court to direct the LPC to supply me with a letter of good standing, which happened.
Because in the court order stated the respondent is interdicted and directed to issue the certificate. So there was resistance. Was there resistance from the Mpumalanga Provincial Legal Practice Council?
Indeed, there was. And when shortlisted, when I was informed by the JSC Secretariat that I've been shortlisted, they indicated in a letter that I also ought to supply them with a letter of good standing. And I approached the professional body, and their posture was that they could not support my candidature, or they could not supply me the letter of good standing. That then necessitated me approaching the court to bring the application. But once the papers were drawn and served on them, I must say that they simply filed a notice to abide, and they did not oppose the matter any further.
From your side, Mr. Thobane, because the suspension was for about 2 years, why did you wait until September 2025 to file an application for suspension to be uplifted?
I understood the suspension to be automatic, because it was a 2-tier suspension order. It said you are firstly suspended to practice as an attorney for 18 months. You are further suspended to practice on your own as an associate, as a director, for a further period of 2 years. So I had to wait for both the period of 18 months plus 24 months to lapse before I could do anything.
And why didn't you comply with what you call it was just an administrative misconduct?
AJP, I at the time had what I can call a modest practice. And when called upon by the then JP to act from time to time, it was for me an honor and a rare privilege afforded to very few. And in a way, I must say that I kept my eyes off the ball. My practice was in the hands of a practitioner whom I expected to help with such administrative issues. I accept that the responsibility lay with me. I'm the one who ought to have ensured that there is compliance. The period of 2 years gave me an opportunity to introspect and reflect. And I am disappointed in myself that I allowed such administrative problems or issues to fester to a point where the professional body thought it fit to discipline me. But what I must say is the following, is that once I had seen that there was trouble coming, I then ensured that I filed the outstanding audit reports and that I do all the administrative things that ought to be done. And when the order of suspension came, my practice had been closed for 14 months, and all the outstanding audit reports had been filed, and all of them had been unqualified.
Do you admit that practicing as an attorney without a fidelity fund certificate it's a serious misconduct? It's not just administrative.
Definitely, I do agree, AJP, and like I've sought to explain, my characterization of the transgressions of the offending conduct as administrative in nature is something that I lifted from the judgment for my suspension, but I readily concede that it is a serious transgression. I was a senior practitioner at the time with more than 20 years experience. I knew the rules, and I ought to have acted better. And I regret that I acted in the manner that I did.
In addition,
I have learned a lesson, and I look forward and leave the past behind.
Mr. Thobane, in addition to that, you were the president of the Law Society, 2010 to 2011. Furthermore, you were a councillor at the Law Society for about 7 years. And as councillors, you deal regularly with practitioners who practice without fidelity fund certificate.
Like I've indicated, AJP, those are serious transgressions, and I'm disappointed in myself that I allowed the situation to fester to that extent.
Thank you, Chief Justice.
Premier?
Thanks so much, Chief Justice. Mr. Thobane, how are you?
I am well, Premier. How are you?
I'm okay. We as a province of Gauteng, we argue very strongly that the bench must have the necessary skills that will assist us to resolve legal matters as speedily as possible so that the economy of the province is not delayed by lack of skills within the bench to deal with some of the matters that are presented in court. I'm trying to get the relevant skills that you feel that you will add in enhancing the skills base of the bench.
Yes.
Take into consideration that we've acted on various occasions in our province. So, can you just take us through the skills that you really believe that you will bring when you can be appointed a successful candidate?
Yes. Thank you, Premier. Premier, I have acted since 2013. During that period, I've been able to produce about 150 judgments. And during that time as well, I have served the bench at the request of the Judge President, who I believe came back to me from time to time because he believed that I've got a skill set that the province needs. And he has requested me on more than, at his request, I have served the province over 204 weeks. I've given them over 204 weeks, which equate to 4 years. And during that time, if I may add, I've been able to sit considerably in the criminal court. I've been able to do most matters that are listed on the spreadsheet from the province. The only kind of work I have not been able to do is tax law. But otherwise, all areas of the law, I have sat in with colleagues, whether it's full bench or full court, and I have, as I said, produced judgment, some of which are reported.
The small claims court plays a critical role in the economy of our province, especially the underprivileged.
Indeed.
And your migration from that level to where you want to go now, don't you think that it disadvantages that particular sector, or what would be the advice with the experience you've acquired that we need to strengthen that small claims court?
There is generally a reluctance, particularly of senior legal practitioners, to participate in that space. More needs to be done to encourage them to avail themselves to act in that space. I have done what I could when I was in my province. We established the small claims court at KwaNdebele, and if I may add also that Marble Hall and Groblersdal, which fall under Limpopo, also did not have the small claims court. And senior legal practitioners in those towns, which are surrounded by people who are in dire need of legal services, did not make themselves available to act in the small claims court. With the result that even though we were from Mpumalanga, we had to travel considerable distances to service those areas even after hours. In fact, because they are after hours. So you would leave your practice around 4, travel for about an hour to Groblersdal, do some 2 to 3 hours, and travel back at night and be ready for your general court work the following morning.
Thanks so much, Chief Justice.
Yes.
Thank you very much, CJ. Good afternoon, Mr. Tuan.
Good afternoon, Commissioner.
I just want to ask you about a judgment that you wrote long time ago, and I don't want to hold you to that judgment because I think personally your views might have developed over time, but I just want to check whether they have. It is a judgment that appears on page, I'll give you the page number now. It is page 18 of your document, and hand paginated 18. I'm not sure if
hand paginated.
Yes, there's the one that has been paginated by a marker.
All right. There's book 2. There's book 2 of 2.
Yeah, probably it might be that one because I don't see the typed pagination. So, but nonetheless, it's the matter of Shebeen investment versus Esther.
Yes.
That was delivered in 2015, and it's the one that dealt with the PI Act.
Yes.
Yes. And in this matter, obviously there was a commercial lease agreement, and you found that the respondents, the tenants, were just playing games, and they were not as poor as they claimed to be.
Yes.
And they are protest for rent and all those kind of things. But what I'm interested in is some of the comments that you made on the judgment, and I just want to hear what your views are currently. Because among others, you said that it was not compulsory to serve the municipality in terms of Section 4.2 of PI Act, or to join the municipality in the proceedings.
Yes.
I'm not sure. Do you still hold that view?
Well, what I found then was that, because these were not indigent persons, these were persons who could afford and who deliberately avoided paying rent and obstructed collection of rent and obstructed the landowner from accessing the property, that they were not deserving of protection.
Yes. No. And please forgive me. I accept the facts for what they are.
Yes.
I think what I'm asking is a different question.
So, yes.
That when you look at Section 4, subsection 2
Yes.
of that particular act, makes it or provides a sense as to who should be served with the Section 4.2 notice, who should be notified about the impending eviction.
Yes.
And the municipality plays a particular role in evictions. Yes, you might join them in the proceedings, you serve them with documents, they don't do anything. Sometimes they provide a spreadsheet where they are telling you, no, we are doing the best that we can, but there's nothing in our available means. What I'm trying to get to is it compulsory, in your view, to join the municipality? In other words, is it compulsory to serve the municipality with the eviction proceedings? The municipality which has jurisdiction over the property upon which eviction is actually sought.
Yes. No, Commissioner, my opinion has since developed. I believe that they ought to be served, and it would be entirely up to them to, yes, whether they abide, whether they oppose, whether they, yeah, but
and if the municipality is not served, that's a ground to strike off the matter from the roll so that they can be part of the proceedings. I was just worried about that, but thank you very much. Thanks, CJ.
Commissioner Mangen?
Thank you, Chief Justice. Good afternoon, Mr. Thobane.
Good afternoon, Commissioner.
Yes. I need to converse with you the court order of the Mpumalanga Division of the High Court.
Yes,
I'm interested in order number 3,
yes,
the one that says that before you can practice on your own account, you need to make an application to court.
yes.
And I want to assume that you have elected not to practice on your own account, and that is why you did not make an application.
Yes.
Instead, you choose to make an application to assume a position with more power and authority than being a director of a law firm. As I see it, your application is actually intended at bypassing order number 3. Am I correct in my reading of that order?
No, that is not correct. What is correct is the following: that in the pursuit of obtaining a good standing certificate, the Legal Practice Council indicated that there ought to be an upliftment for them to supply me with a certificate. The court ought to grant me permission to practice. And once the court does that, in other words, lift the suspension, they will then supply me with a good standing certificate.
I'm talking to you about a completely different matter.
Oh, I see.
I'm not interested in the letter of good standing.
Yes.
The position you now seek to occupy carries more power and authority than that of a director of a law firm.
I agree.
And the court has said to you, before you assume directorship, you've got to come before it and satisfy that court that you are a fit and proper person and you can be trusted. But instead of doing that, you bring an application to be a judge when you have not gone before the court that said that there is some character defect in you and you cannot be trusted with responsibility of managing a law firm. You, as I see it, you first have to prove to us and the country that you can be entrusted with a small institution like a law firm before you can actually be entrusted with the responsibility of taking care of adjudication of legal disputes in a society. And I have serious difficulty that you do not appear to be taking these court orders very seriously, because it is said that these orders still stands, and up until they are set aside and or reviewed, they remain binding.
Well, the judgment does not say I've got a character defect. It's a different determination that was made. The judgment specifically says that the respondent, which was me, we are not dealing with a person with a character defect. So characterization of my offending conduct as amounting to a character defect is not how the court found.
Commissioner Pillay?
Thank you, Chief Justice. May I just ask you to please have a look at your application in addition to what Commissioner Mangena has put to you? Just want to raise a related concern. Can I ask you to open up your application form and specifically go to item 3 of your application form?
Sorry, where?
It's on page 13, handwritten 13.
Yes.
You asked there, has any legal professional body ever found you guilty of unprofessional or disgraceful conduct, or are there disciplinary proceedings pending against you? And I just want you to have a look at your answer. You say, on the 17th of May, I was suspended from practice by the High Court and precluded from practicing until September 2021. And the transgressions were administrative in nature. But that's not an accurate portrayal of what the High Court had said in your suspension order.
Well, it's not. It's not. I have not couched it as it was couched in the order itself.
Yes, you gave the impression that your suspension lapsed in September 2021, when in fact it didn't lapse.
Well, that was my understanding of the order at the time. And hence I approached the court for upliftment when the Law Society said you were suspended by a court and only a court can uplift your suspension.
Mr. Thobane, with respect, if you look at the High Court's order, there could never have been any misunderstanding about what the court ordered. It's very clear. The court says, firstly, that you are suspended from practice for a period of 18 months to be calculated from the 13th of March 2020. That's what you reflect in the form.
Yes.
So that would have ended in September 2021.
Yes.
The court goes further. It says that you are precluded from practicing as an attorney for your own account, either as a principal or in partnership or in association or as a director, for a further period of 24 months.
Yes.
From the expiry of the suspension. So from September 2021, there's still a further period of 24 months where you can't practice for your own account.
Yes. My reading of the order was that
But can I just ask you, that's not disclosed in your form?
Well, that is true. It's not couched in that manner.
Didn't you think it was necessary to disclose that portion of the order?
Well, I have subsequently supplied further information.
No, I'm asking Mr. Thobane, at the time that you were completing your form,
Yes.
didn't you think it was necessary to disclose that part of the order?
I should have.
And any explanation for why you didn't?
Well, it was just an omission, and perhaps I ought to have given further detail about the order of suspension.
Because you see, it gets worse, Mr. Thobane. If you look at the third part of the order,
Yes.
the court goes even further. They say that should you, after expiry of both periods, so September 2021 and then 24 months from that period, so after the expiry of both periods, should you elect to practice for your own account, either as a principal or in partnership, you must satisfy the High Court that in which you so intend to practice, that you should be permitted to practice. So, in a sense, it's almost a suspension, not time bound, until you come back to court and persuade the court that you should be allowed to practice. That's not reflected in your form.
Well, I accept that it's not reflected. And the first portion of the suspension was that I could not practice for my own account. And the second portion then says, should I wish to so practice as a partner for own account, as a director, then I ought to satisfy the court.
You see, Mr. Thobane, your failure to disclose this has quite serious consequences. And I need to put that to you. It means that at the time that you submitted your form, that you were not entitled to practice as an attorney?
Well, that is not my understanding. I was not entitled to practice as an attorney for own account as a director or in partnership.
All right, let me nuance my question. At the time that you submitted your form, you were not entitled to practice for your own account as an attorney. And that's not disclosed to the commission.
Well, that is not my understanding, Commissioner. My understanding was that the first period of suspension, that of 18 months, precluded me from practicing as an attorney.
Yes,
Then the second leg,
the 24 months.
yes, the second leg of 24 months, precluded me from practicing for own account, partnership, or as a director.
Yes, and the third leg, the indefinite one?
Well, my understanding, if I may just finish this portion, my understanding was that after the 18 months had expired, I could practice as a professional assistant or I could practice in any other manner, but not as an attorney for own account.
Yes, and that applies to the third leg as well, which is the indefinite period, until you come back to court and persuade a court that you should be allowed to practice for your own account.
The third leg, as I understood the order, was that if I want to practice for own account, in partnership, or as a director, then I ought to approach the court for relief.
So you're agreeing with me, Mr. Thobane, that as at the time that you filed your application, that you were not entitled, you could not by law practice for your own account.
I agree.
Now, the consequence of that is, as at the date that you filed your form, made your application, you were not entitled to a certificate of good standing.
Well, my understanding was that the first suspension period having expired, I could be issued with one.
But you now know what should have been very clear to you. You're a senior attorney, you established attorney. You now know because your law society has told you that, the Legal Practice Council has told you that prior to the 4th of September, you were not entitled to a certificate of good standing.
Hence, I approached the court for them to issue me with one, as the entire period had now expired.
And so your upliftment of that portion of the order only comes on the 4th of September.
Yes.
Not at the time that you submitted it. So what I'm putting to you is, at the time that you put in your application was non-compliant. But nobody picked it up because of how you had framed this response in your form, because you were not entitled to a certificate of good standing at the time that you filed your application.
Well, I can see how it can be interpreted in that manner.
Thank you. Thank you, Chief Justice.
What do you mean you can see how it can be interpreted in that manner? Do you accept that this is the only interpretation that can be given to it?
No, Chief Justice, all that I'm saying is that I prepared the form, the questionnaire, and gave the impression that...
I just want to know if you accept what Commissioner Pillay put to you unequivocally.
Which is what, Chief Justice?
What she put to you? What did she put to you?
Well, she says at the time, the application was not compliant.
Yes, and it's your answer that I don't understand, that you can see how it can be interpreted that way. Do you accept unequivocally that when you applied, you were not entitled to a certificate of compliance? And you actually had no right to apply for this position?
I accept, Chief Justice.
Okay. Commissioner Gauteng?
Thank you, Chief Justice. I think it's just two parts, Mr. Thobane, which really follow up on your discussion now with Commissioner Pillay. Your characterization that the judgment that suspended you stated that the offenses were administrative in nature. You remember that?
Yes.
And you also remember that you said to Commissioner Mangena that judgment said you had no character defect.
Correct.
Now, the problem I have with that is that it is a selective and a misleading reading of the judgment. If you go to paragraph 111 of the judgment, what the court actually said,
Sorry, where do I find that?
paragraph 111 of the judgment that suspended you, the LPC versus Thobane.
I am struggling to.
Yes, all right. Well, trust what I'm reading to you.
Yes.
We don't have a lot of time. In paragraph 111, this is what the judgment actually held. And it was on sanction, not on conviction. The respondents' transgressions were serious, particularly when viewed in their totality, and can therefore not be gainsaid. The question is thus whether these transgressions are serious enough to warrant the penalty of striking off. In the present instance, a penalty of striking off might be too severe, considering that the offending conduct was largely administrative in nature and does not disclose, again, a permanent character defect in the respondents. However, the respondents' misconduct was continuous and displayed a complete lack of insight, justifying specific protection of the public calling for additional measures. So, firstly, your characterization that the judgment said these were administrative offenses actually doesn't tally with the language in the judgment. And your characterization that the judgment said you had no character defect also doesn't tally with that, because it simply said your character defect is not permanent. Hence, I'm saying your characterization today, I'm not talking about what you did in the past, today is misleading.
At best, what I can say is that the suspension, since it had periods, 2 legs to it.
No, you've debated that with Commissioner Pillay. I don't want to get back to that topic. What I am talking about is that the way you've characterized administrative as well as character defect is misleading. On character defect, what they said is that your defect is not permanent. They didn't say you had no character defect. On administrative, what they said is that these offenses are largely administrative, but extremely serious. None of those came in your responses. So what I'm putting to you is whether you accept or reject my suggestion that I feel misled.
Well, if that is the, well, I did not have the intention to mislead.
Yes. Thank you, Chief Justice.
Thank you, Chief Justice. Mr. Thobane, I find you've applied previously for this position in 2016, am I correct?
Yes, I have.
Okay. And you also served on the Council of the Law Society of the Northern Provinces for the period 2006 to 2013.
Yes, I have.
That's 8 years on the council. You also served as its president in 2010.
Yes.
So how is it that somebody with inside knowledge of how the council works, how the Attorneys Act functioned in those years, came to neglect your practice to the extent that you were suspended for this period of time?
I have said that after a period of reflection, I am disappointed in myself that my circumstances had to arrive at that. I was a senior practitioner at the time. I knew the rules and allowed such a situation to develop.
Was that all from you, Commissioner?
Thank you, Chief Justice.
Commissioner Matolo Dlebu?
Thank you, CJ, and good afternoon, Mr. Thobane.
Good afternoon, Commissioner.
I just have to declare that I served with you at the Law Society then, and I know you
Indeed,
you're
we
very
have.
conscientious attend. But don't you think you need to go back and deal with the court order first before you make another application? Or for me, you as Commissioner Pillay said, you dealt with only a part of that application. You need to go back to court. Make sure that by the time maybe you want to apply again, at least that court has been assessed.
Go back to court to practice or what?
Go back to court for them to uplift your suspension properly. Remember when you do an application, you go to court after a suspension, what will normally do? They'll give you conditions. You can do this with the suspension after you get, maybe you go for a accounting course for 6 weeks or whatever it is. I think do that, those steps, you know that.
Yes, Commissioner, but the order simply says if you wish to practice for your own account in directorship or in partnership, you ought to satisfy the court in the area in which you wish to practice. And what I did with, or what I sought to do with the application was to show or to satisfy the court that I ought to be given permission to practice. The language that was used by the court is to that effect. But I accept that if the view is that the court, in fact, that is not a suspension upliftment, the order that I obtained. But the couching of the order, unfortunately, led me to take the action that I did. You are suspended from practice as an attorney, number one. Number two, should you wish to practice for your own account, you must satisfy the court that you should be permitted to do so. So I went to court and I sought to satisfy the court that I be permitted to practice, and the court granted that order.
Thank you, CJ. That was my advice.
Thank you, Commissioner.
After the conversation you've had with the commissioners from that end of the table about the effect of the order of the High Court, all its elements, and what you have considered now, do you still insist with this application?
No, I don't.
Do you think you are ready to
No, I don't.
jump onto the judicial bench?
I don't. I will go and correct the situation.
Okay, thank you. Thank you, Mr. Thobane. You're excused.